Welcome to the Special Education Essentials for Parents and Families podcast with your host, David Tollner. In each episode, we'll have guests who are professionals in the special education and disability services industry who support children with special needs. The law is complex, and this podcast does not cover all situations, legal responsibilities, or variations in different circumstances. This podcast is for entertainment and informational purposes only, and nothing contained in this podcast should be construed as legal advice. The views expressed in this podcast may not be those of the host or the firm. We are not responsible for any losses, damages, or liabilities that may arise from the use of this podcast. This podcast is not intended to replace legal advice. You can find this show on all the major platforms including YouTube, LinkedIn, Facebook, Apple Podcast, Spotify, and on our website, TollnerLawOffices.com. Now, here's the host of Special Education Essentials for Parents and Families, David Tollner.
Yes, welcome everyone to the very first episode of Special Education Essentials. I am your host, David Tollner. A little bit about myself so that you know who you're listening to. I have been a practicing attorney in California for 35 to 40 odd years. The first 15 of those or so, I was a business litigator, a relatively unhappy one, as it turns out. And so I left the practice of law for 5 or 6 years to run two nonprofits, one called PACE in Sunnyvale, California at that time. And it was a big school for children with autism, and then 6 group homes. I left that after a few years and ran an organization called Rebecca Children's Services, which was and still is the other side of the disability spectrum, which is mental health, as opposed to autism, which is a developmental disability, as most of you will know. After that, after falling in love with all of the kids that I managed during that time frame, I reinstituted my license and became a special ed attorney, and I did that about 18 years ago. And since then, I've grown a practice here based in San Jose, California. We've got 2 attorneys in the Los Angeles area, and we cover all 4 corners of the state of California. This, of course, will go out nationwide eventually. And all of these, everything I'm going to talk about during the course of this podcast, both today and many, many, many weeks into the future, should apply nationally, right? California is a little different. It's obviously a very liberal state, so the judges here that work in special ed, we may have better decisions that are more student-friendly, but the law is the same, right? The law all comes from the federal IDEA, the Individuals with Disabilities Education Act, right? That's the body of statutes, or the statute that we all rely on nationwide. So that's what we're talking about when we talk about the legal side of special ed and IEPs, right? So the point of this podcast, both today and well into the future, is to give valuable information to parents of kids with special needs, right? This IEP process, when you first get into it, is very complicated. Nobody knows it. Half the districts don't know it very well, but you walk into these IEP situations and you're alone, right? You have this team that is there, potentially to help your child succeed in school, potentially to drive progress as much as they can, but it doesn't seem to work that way. And so what you need to do, and we'll talk about this at length, of course, over the next 3 episodes in particular, and then we're going to interview a bunch of people in this industry, from IE assessors to teachers, special ed teachers, to BCBAs who run ABA clinics, to speech therapists. So part of this podcast is going to be about a number of things. We're going to start with the first 3 podcasts as an introduction to what I call my IEP 101 talk. It's a talk I've given many, many times in the past, and it's 10 key rules, if you will, of going into an IEP prepared to get the best out of it, right? To make sure that your child is progressing as much as possible, using that IEP team and the services and supports from the district to make that happen. Most parents don't know these rules, right? And they certainly don't use them. And if they did, their IEP outcomes would be much, much better. And so the first 3 are going to be me walking through those 10 rules. The 4th and thereafter, I'm going to be interviewing people in this industry, right? Everyone from special ed teachers to IEE assessors, and we'll get into what an IEE is at some point over the next 3 weeks, and anybody else that has a hand in this industry, which is the industry of children with special needs, right? It includes autism, dyslexia, obviously mental health issues like high anxiety and depression, and everything in between, right? So there's a huge spectrum of kids that qualify for IEPs. And once they qualify, and we'll talk all about all of that, obviously, then you're in this process. And the more you can learn about this process, the better your child is going to do. So we're here, and this entire podcast is about getting you better prepared for your next IEP. So let's get to it. All right. Today, we're going to talk about 2 or 3 of the IEP rules. And the next podcast will be 3 or 4 more. And then the next podcast, I'll wrap that up. And then as podcasts go on, I'm going to reference these 3 podcasts because the meat of what I'm going to be talking about throughout the entire time we do this is going to be in part these 3 podcasts about the rules of a better IEP, because then what I want to do is interview people about various aspects of these 10 rules, because it's these 10 rules that are going to help drive your child's progress in school more than you've seen thus far, is my guess. And in some cases, it'll be night and day what you see. All right. Rule number 1, and it's number 1 for a reason. It is also the simplest thing you can do. Every 2 through 10 you're going to find can be complicated and take some prep work. Rule number 1 takes almost no work at all. And the rule is record your IEPs. Record, record, record. There is no good excuse for not recording. And I've heard them all. Right? Clients come in, man, I don't want to record. I have such a good relationship with the school and the staff there, and it just feels like I'm, creating conflict. Bad reason to not record, right? Or, you know what, I just, everybody's doing so well, and everybody seems to care so much about Johnny that I don't really want to send that message that I'm raising the stakes here in this meeting. No matter what you've come up with as your excuse for not recording, it is not, on balance, more important than recording what is said at every IEP from now on. And here's why. When you go to an IEP, you may be taking notes, but those notes don't become a part of that IEP. And we're going to talk about, however, making those notes become a part of the IEP, but that's at the end of this, of our 10 rules. You walk into this IEP and they create the notes, and then they attach those notes, whatever they were, at the end of the IEP typically. And that becomes the contract, if you will, that you have with the district, the things that they're going to do. But if something is said at that IEP that isn't captured in the notes, and you don't record it, and it's a valuable statement, something that supports what you want for your child, right? Some support that is needed in school, it's like it went into thin air. It's like that statement never happened, right? Because there's no record of it, because you didn't record. And if you don't record, nobody else will. But it's also right? It's also, there's a rule in litigation primarily, but definitely in special ed, that says if it isn't in writing, it didn't happen. The judges in this industry, and whereas in other industries, he said, she said, that's an important thing for the judge and a jury to weigh. They don't like to weigh, he said, she said, in special ed. Everything that is meaningful must be in writing, or what we see again and again and again, particularly from judges' rulings, is that if it's not in writing, it didn't happen. So if somebody says something critical to your child getting a support or a service they need to make progress, meaningful progress in their IEP, and you don't record it, and it doesn't end up in the notes, it did not happen. It was not said. So you have to go into that IEP, and there is no good reason not to. With a recorder, you have to give notice 24 hours in advance. You just simply do it by email. You send out a one line. I'll be recording. You don't have to ask to record. You tell them you're recording more than 24 hours before the start of that IEP. Then it's your legal right to record. So you go on Amazon, get a $45 recorder, or use your smartphone. Some of the smartphone recording apps are actually pretty darn good. You just got to make sure you put it in airplane mode before you record. So if somebody calls in, it doesn't shut off and you lose valuable stuff. You get around that by getting a cheap digital recorder with a little extension that you plug into your laptop, and you can download it and keep it there if you want. That's what we do and what you should do and certainly could do. But you have to do that. You have to do one of those things, and then you give notice, and then you just turn it on, set it next to your laptop if you're in a virtual IEP, or bring it to the IEP if it's in person. You set it down and you capture everything. And as we go through these 10 rules over the next few podcasts, you're going to learn how valuable that is, how you can take from statements that were made and create a story that makes it very difficult for a district not to provide your child, right, with the supports and services they need or the placement that they need to make meaningful progress. So that's the key. That's what you need to do every time. There is no good excuse for going to an IEP again without recording it. 24-hour notice, use your smartphone if you need to, and record every word. You turn it on when you get there, right when everybody starts talking, and you turn it off when everybody stops talking, and that's it. And you record all 2 hours or 1 hour or whatever it is. And then if you never listen to it again, hallelujah. That would be great, because they're a pain in the ass to listen to. But it's there. And it's there, and they know it's there. All right. So what is rule number 2? Rule number 2 is you're being recorded now. That's rule number 1. And so you have to be respectful. It's the key to getting what you want out of an IEP. There are a few cases, I will call them, right, where I have a client who is so anxious, so angry, so out of control with what they will say and their accusations of school staff and administrators. Very few that will get what you want, right? Because nobody wants to deal with you, and they will just give you what you want just to send you away. I've seen that happen, but it is rare. Most often, what happens is this. You turn off everybody in the room, but you have to be very careful, because who you're also turning off is anybody from the outside, right? Who then, because you now are recording, and potentially a judge now, right, who's listening to this, it is going to see you as an unreasonable member of the IEP team. And if you're accusing the IEP staff of doing something, if you're insulting, judges hate it. They hate it. They will almost always rule against a parent that has crossed the line at an IEP meeting. So if you are one of those, maybe that's the one excuse, quite frankly, for not recording, is if you're a screamer and a yeller and you need to insult everybody on the team. But that won't get you, except in the very, very, very few situations what you want. Instead, record and be the prepared, respectful person in the room. If you're the prepared person in the room, right, you're going to get more from that and being respectful but firm than you will from being accusatory and insulting. All right, so that's the basic framework of these two first rules, right? Record and then be respectful but firm. You certainly don't want to get walked on. They will walk on you. Some school districts certainly will. Others will treat you very much as an equal member of the team. But listen, we're called in and hired by people for a reason, and it's typically because they're treated rather poorly at IEP meetings. And I can't tell you how often I've been told that the IEP that I first go to is the best IEP that has ever happened, right, that they've ever been a part of. And that's because I'm an attorney and I'm there, and they know I'm there to represent this child who is not doing well, or I wouldn't be there. Nobody hires me to come in and if their child is doing great in school, right? They hire me to come in and improve the educational outcomes for their child, particularly when much time has gone by with zero to very little progress and very often regression over time, right? Things are getting worse, not better, right? And so at some point, somebody wakes up and says, all right, it's time. We can't do this anymore. We're out of our league. Let's go talk to somebody. All right. And so I walk into these IEPs, of course, and everybody's on their best behavior. But that helps even when you record, because they know you're recording, and they know that if they say something accusatory to you, you're going to use it, because judges hate that also. So recording is very important. You be the respectful but firm person in the room. And those two things alone are going to drive more progress than if you're the angry parent that is insulting everybody on your way out. Okay? That leads to the third rule. And then we'll let it go there, because that's enough. And then we'll pick up on number 4 next week. Rule number 3 is very important. Prepare. Okay? You've got to be prepared, which means you have to read the IEPs, you have to read the reports. Nobody knows your child better than you. We have a rule in our firm there's very few exceptions to, and that is that our parents know their kids better than anybody, even when it comes to school issues. Every once in a while, we'll run across a parent who has just no clue what their child needs, right? No clue whatsoever, even for a 6th, 7th, or 8th grader. But by the time most parents get to middle school, or even 2nd and 3rd grade, they've done enough research. They know what's going wrong with their kids. They know what their children need, right? And we listen to that, because we find that far more often than not, they're right. All right. And you need to take that information, not just from a parental perspective, which is very important, but also be the one in the room that has read the file most recently, that can access key parts of the file, right, readily. Very often you'll walk into one of your IEP team meetings and no one will have read that file. Not a single person except you. And you want to be the person that not only has read that file, but that understands it better than anybody and can point and reference pieces of it that are absolutely essential to getting what you want out of that IEP. And what we'll talk at length about when we come back in a week is don't ever go into an IEP without knowing what you want, right? That's very important. But as you figure out what it is you're after that you think is going to help your child do better in school, knowing that file backwards and forwards, knowing the keys, right? The parts of that file that support what you want, so you can reference it and put on the record those important points is very, very important to the success of your child. Be the prepared one. Be the respectful one. Record all of the conversation. And those three things alone are going to send you in the right direction for your child's IEP, right? You'll be ahead of the game. And you can even ask everybody when you get to the IEP, has anybody read this report I sent in? Or when was the last time anybody read the psychoeducational evaluation of a year and a half ago? Right? There's so many things that a teacher walks in, and very often a teacher will be with your child for 4 or 5 months. And you'll go to a IEP in January, the first IEP of that year. Let's say it's the annual. And you'll discover then for the first time that teacher has not even read your child's IEP, and it's January, right? So you have to be, right? That's not uncommon. So you have to be the one that knows your child better than anybody else, not just from a parental perspective, but from a documentary perspective in terms of all of the documents. And when your kid's on an IEP, there's a few, and this sounds daunting, and it can be as we get older and we have a lot of documents to choose from. But you need to be the one who understands those documents and what's in them better than anybody else. And you don't have to go back that far, right? There's a 2-year statute of limitations in special ed. That's it. And so you definitely need to go back at least that far. So 2 IEPs and at least 1 district evaluation, right? At least know those very, very well. Because as you're looking at those, and particularly the baselines in the goals in the IEPs, and you're seeing no to very little progress from one baseline to the other, that's important information to put on the record. Because little to no progress means violation, right? That is not FAPE. The district's obligation, legal obligation, is to offer FAPE to your child, which is an acronym most of you will know, that stands for free and appropriate education, right? Free because you're in public school, but appropriate, which means leading to meaningful educational progress in accordance with the circumstances of your child. So as you're reading through these documents, you're looking for, and because you're listening to me, you're probably worried about your child, I would say. Well, that goes without saying, but worried about a lack of progress already. And you're looking for evidence of that. You're looking to be able to tell that team, listen, this is not meaningful progress. And I know it's not meaningful progress because I had a tutor work with Johnny 6 months ago. And in one-on-one settings, Johnny learned a tremendous amount, right? He was doing very, very well. Then I stopped, sent him back to school, and his math progress stopped on a dime. And we see no progress, right? Except during the summer when I hire a tutor. And it's that kind of information that informs the team of what more is needed for Johnny to make meaningful progress. But unless you can identify and put on the record that Johnny isn't making meaningful progress, and you do that simply by scouring the record, the district is not going to agree with you that he's not making progress. They'll make blanket statements that progress is being made, and then when you dig in, you realize it isn't. Or when you graph the data points associated with IEP to IEP year after year, right? There's obviously a lot of detail in here. Obviously, in these first 3 or 4 rules, we're not covering the detail. And we will as this podcast goes on. That's my promise to you, is to get into the weeds on these things. And then you can pick and choose from the title of the podcast what works for you, what you need to listen to. But I would suggest to you, listen to all 3 of the first podcasts in this series. And then, and I, of course, would encourage you to listen to everything after that, the interview part, as we go back with the interviews and really dig down and get the detail that you're going to need to really be effective at your child's IEP. All right. I think that's enough for episode number 1. Thank you very much for listening. I hope that was helpful to some degree. I think we'll get more helpful, and we'll get certainly more examples of things to do as we move forward with our rule list. And then again, we'll come back and hit the detail week after week thereafter. Thank you very much for joining us. I hope that was what was informative and useful. And I hope to see you at an upcoming podcast. Thank you.
You've been tuning in to the Special Education Essentials for Parents and Families podcast with your host, David Tollner. This podcast is not intended as legal advice and does not create an attorney-client relationship. Please talk to your legal counsel about your own situation. You can find this show on all the major platforms, including YouTube, LinkedIn, Facebook, Apple Podcast, Spotify, and on our website, TollnerLawOffices.com. Thank you for your positive reviews, comments, questions, and for sharing this show with others.